Good evening, everyone. Welcome to Tiller House. I'm Mark Agrast, Executive Director of the American Society of International Law, and I'm pleased to welcome you here for this discussion of the Age of Accountability for International Crimes, Lessons for Success. I was glad to see that title. It's good to begin the conversation on an optimistic note and to remind ourselves of the considerable success that has been won in building a system of international criminal justice, while at the same time recognizing the challenges we face in achieving true accountability and deterring and preventing war crimes and atrocities. The American Society has been engaged in a 2-year project of our own called A Signature Topic, focused on atrocity prevention. We've been doing a series of programs and activities designed to focus all of our attention on these important issues. This program tonight is part of that initiative, as is the next program in our series. I want to call your attention to that. It's called Mind the Gap, Global Fragility and Atrocity Prevention. It will take place here in this room next Tuesday, February 25th. The speakers with us today have all played an important part in those successes. Diane will introduce them to you shortly, but let me just take a moment to recognize the work of, frankly, all of the people on this panel, all that they have done to advance the cause. But I particularly want to mention our good friend and colleague, David Crane, who you will hear from, who's done so much, both as a prosecutor and as an educator, to shine a spotlight on these issues. I also would like to acknowledge our co-sponsors for this event, the Center for Victims of Torture and the ABA's Center for Human Rights and its Criminal Justice section. And now, it's my pleasure to give the floor to our moderator, a longtime leader of the Society and a professor of law at American University, Washington College of Law, Diane Orentlicher.
Thank you, Mark. Good evening. It's a real pleasure to participate in this evening's program for a lot of reasons, but most obviously because it addresses issues that are both deeply, deeply important and fascinating. And despite the sober subject matter that we'll be talking about, I also know from working with colleagues on the panel and many of you in the audience that there are so many messages of hope, too, that we can extract from the rich experience that is represented on our panel. Let me first briefly introduce my guest before I say a few more framing words about the program. The format will be that I will turn to panelists and ask a series of questions and then open the floor to a broader discussion. But first, let me introduce our eminent panelists and say that that a longer bio is available for each of them, which is a great relief because they all have fantastic resumes that are so rich with experience relevant to this topic. And I don't want to take up too much time telling you all about it. So David Crane was, as I think most of you know, the first chief prosecutor of the International War Crimes Tribunal in West Africa called the Special Court for Sierra Leone, or known in business as SCSL. And we'll be talking a fair amount about that court this evening. It's known, among other things, for having successfully prosecuted Charles Taylor, the former president of Liberia, whom David indicted when he was a sitting president. So it was a landmark case in many different ways. David, as hopefully you know, recently published a book on his experience at the court called Every Living Thing, which I have just received and I'm dying to read, but I've already heard it's a fascinating read and provides a vivid and really illuminating account of his daily experience as Chief Justice of this historic court. Copies, I believe, are available somewhere outside this evening. Somewhere this evening nearby, more close at hand. That's all I can say. More recently, David's been a leading force in seeking justice for the people of Syria through the Syrian Accountability Project. as well as assisting in the creation of the International Impartial and Independent Mechanism for the Republic of Syria. Only lawyers and UN officials could come up with names like that.
Well, since we're telling real quick stories, I originally went to the UN with the idea of calling it the Syrian Accountability Center, and somehow over the next 2 months, it turned into that.
Yeah. Lawyers. Okay. Tom Sheehy was the staff member on the Committee on Foreign Relations of the U.S. House of Representatives for over 20 years, working for Congressman Ed Royce. During his time in the House, he was staff director of the Africa Subcommittee for 8 years and staff director of the full Foreign Affairs Committee for 6 years. He was closely involved in working on the issues surrounding the Special Court for Sierra Leone while he was on the Foreign Affairs Committee. Among other activities today, he's a fellow at the U.S. Institute of Peace, where his work focuses on Africa. Professor Jane Stromseth teaches at Georgetown Law School, where she works as a scholar and teacher on issues of justice and accountability for atrocity crimes, focusing in particular on post-conflict justice and rule of law capacity building. Her scholarship in this area is deeply informed by her experience in the field on the front lines. From 2013 to 2015, she served as deputy to the ambassador at large in the Office of Global Criminal Justice in the Department of State. That sounds like a wonderful job. Love to have that. And then as acting head of the office. She's a member of the State Department's Advisory Council on International Law and counselor at the American Society of International Law. Previously, she served as senior advisor on rule of law and defense. And I'm sorry, I think I'm mangling this. Senior advisor on rule of law and international humanitarian policy at the U.S. Department of Defense and director for multilateral affairs at the National Security Council. So as I indicated earlier, I'm going to briefly say a couple of remarks to put the discussion in a general framework and then direct some questions to our panelists. As our program description suggests, by now the field of international criminal justice has a history. It's got a deep history. It's now marking its 75th anniversary, and more particularly the 75th anniversary of the creation of the Nuremberg Tribunal. And in a minute, I'm going to turn to David and ask him to reflect a bit on how that precedent influenced his work at the Special Tribunal, Special Court for Sierra Leone. So we've developed a really rich body of experience and practice. And during that period, fortunately, have developed a lot of insights into kind of what works, what's effective, what are some of the necessary elements of delivering justice in the worst kind of possible settings. And it's sort of ironic to talk about success when we talk about this field because, as we know, these war crimes courts are only established when things have gone terribly, terribly wrong. So we're talking about one of the most challenging contexts in the world to work on. That's why it's really a privilege to be able to direct some of these questions to people who have depth, expertise, and successes that we can sort of hopefully draw out. So I do want to first begin with a little bit of a historical perspective. And David, I'm going to ask you to begin by talking a bit about how when you took over the job as chief prosecutor, took over as first chief prosecutor. I don't mean you took it over from someone. You charted this path yourself. I want to ask what you learned from the experience of the post-war tribunals, because there had been a long period when we weren't practicing in this area, and you were part of this new breed of court. And then, Jane, I'm going to turn to you next and ask you to sort of fill in a little bit more of the historical perspective from the U.S. government perspective. But David, as a practitioner,
thank you.
Could share your experiences.
Well, thank you, Diane, and it's such a pleasure. And a good majority of the crowd, I actually know you and know you personally, so thank you for coming out. This is an important topic to be sure. But the heroes to my left and right who mostly labor in the shadows, for those of us who tend to be in the spotlight, are critical and very, very important. Some of you in the audience were the same way. So Not that I'm going to be shamelessly plugging my book, but somewhere in my book, I tried to highlight every single person who did something positive for the people of West Africa, particularly Sierra Leone. And I'm very pleased and honored that my two colleagues here and my colleague on my left who agreed to join me. But let's get to the question. Thank you for coming. My goodness, Nuremberg, 75 years ago. We didn't do this kind of thing, but for that one time, this crazy moment where in the middle of this hell on earth, literally, someone suggested that we prosecute these individuals. As you probably have heard, I see many scholars in the room itself, but you've heard the story. I believe it was in Yalta, where they sat around and looked each other in the eye and said, what do we do with these guys? What, the leadership of the Nazi party? Well, Winston Churchill immediately said we should identify them and shoot them. That was his going in bargaining position. And Joseph Stalin was horrified. The murderer of, at the time, he hadn't quite, he's individually criminally responsible for the destruction of over 34 million Soviet citizens during his time frame. That's not counting the 22 million in World War II. Was horrified that Winston would say such a thing, because we should have a trial, and then we'll take them out and shoot them. How Soviet. Well, of course, during this time frame, President Roosevelt had put together a group, and they were actually studying this and working hard on this, and he proposed a trial where we go in and prove the case. And, really, Stalin didn't care, and Winston Churchill really didn't care. This is not one of those fall on your sword moments for these two leaders, so they just agreed. And in 8th of August of 1945, of which we will celebrate that moment in London at the International Humanitarian Law Roundtable, which some of you have been a part of, and we're actually going to celebrate that moment on 8 August, on the 75th anniversary of the signing of the London Agreement, which created the International Military Tribunal. I'm going to give too much detail, but the International Military Tribunal at Nuremberg, and then there was another one in Tokyo, was a first attempt to inject law into a horror story and to try to seek justice in a way that we could account for what took place. And that happened. Well, fast forward over almost 50 years worth of a dark spot called the Cold War, where over 95 million human beings perished. More people died during the Cold War than World War I and World War II combined. It's a fact of history very few people notice. The wall came down. We all remember that moment, some of us a lot more than others, and we said, oh my goodness, it's a new world, it's a new world order. But sure enough, within a year and a half, 2 years, as all of this political situation starts to unravel with the Cold War, stresses and strains happen. Of course, the Balkans unravels, and we see the first genocide in Europe since World War II. And again, a moment, and this is so critical. This is the crossing of the Rubicon moment. This is the beginning of the age of accountability, is that the international community, flush with victory, I guess, for lack of a better term, decided we're going to create an ad hoc tribunal called the ICTY, the International Criminal Tribunal for the former Yugoslavia, and they began to put a court to hold people accountable for what was going on in the Balkans. And then a crazy 9 months later, all of a sudden, we see the horror that's Rwanda, and they turned and created those courts. Now, during this time frame, this 10 years, 1991 through 2001, there's a dark corner of the world called West Africa, mining diamonds and gold and timber, and the destruction is horrific. And finally, the president of Sierra Leone wrote a letter to Kofi Annan saying, and to the Security Council saying, I can't do anything. I have a horror story here. We have over 1 million human beings gone, and it's continuing. I need help. And so the Security Council said, I'm not sure we want to do another ad hoc. And we can talk about, at that moment, they weren't doing very well and at a huge cost. And so they tried to decide to do something different and not put it in The Hague, but actually put it like at Nuremberg at the scene of the crime. So they decided to create the international, or the hybrid International War Crimes Tribunal in West Africa called the Special Court for Sierra Leone. It was an experiment, a bold experiment. Can we do this better? Can we do this more efficiently and more effectively? And so that's when we can talk more about that if you want a question and answer, but I get this phone call at 7 o'clock, just down the street. We're about to eat dinner, and it was the National Security Council asking if I'd like to be the nominee, and so the rest is history, and I was appointed. But I'll just give you a little vignette, and I'm full of vignettes. I remember sitting in June of 2004, the first opening statement against the Civil Defense Force, one of 3 warring groups, and we indicted all the leadership of these warring groups. Sitting in there with my robe and my charbot, and I had read throughout about a month prior Telford Taylor's book, because there's no books written on this. Chief prosecutors tend not to write anything about this stuff. And so Telford Taylor's book, I was reading that, trying to kind of get juiced up as I'm writing the opening statement. The first opening statement by an American since 1945. And so Robert Jackson was constantly on my mind. But it's a special moment as you're sitting there and you have all of these people from Sierra Leone in the courtroom behind you, and judges come in and you all stand up, and then they make an opening statement, and then the presiding judge looks at you, says, "Mr. Prosecutor, your opening statement." And I remember the lectern was right there. I remember walking towards that, imagining what Robert Jackson must have, and I'm not holding myself out to be anything close to that great man, but what he must have felt when he had the very same words, "Mr. Prosecutor, your opening statement." And so I walked up there and started my opening statement. All 3 opening statements are in as an appendix to the book. Another plug, sorry. Anyway, Nuremberg was hugely impactful because it was the cornerstone by which we were able to then build what we call modern international criminal law that was the Yugoslavia Tribunal, Rwanda tribunals, Sierra Leone, and some others too, Cambodia and others. But the 3 international tribunals that were international tribunals for those. And of course, then it is the cornerstone to the International Criminal Court.
Jane, could I turn to you to fill in a little bit more of the backstory in terms
I was a bit brief.
using that, talking about the historical experience as a platform for discussing the U.S. complicated engagement with international justice again, by way of background.
Absolutely. Well, first of all, I'd like to say how happy I am to be here with David and my co-panelists, and thank you to ACIL for hosting this conversation. The U.S. contribution to global criminal justice, I think, has been quite substantial. And on the sort of very affirmative note, beginning with the contribution to the Nuremberg Tribunal, its establishment, its chief prosecutor, and the U.S. efforts over the decades to support both the law and the institutions set up to hold individuals accountable for the worst international crimes, genocide, crimes against humanity, and war crimes. And not only the tribunals that David mentioned, Nuremberg, Tokyo, the Yugoslav and Rwanda tribunals, but as he also mentioned, the hybrid courts, the Special Court for Sierra Leone, the Cambodia Tribunal, regional courts like the African Union Senegal Tribunal, which has brought Chadian dictator Hassan Habre to account, and currently hybrid courts in the Central African Republic and in other situations as well as domestic accountability efforts. And one thing about the hybrid courts, which I know David will talk about further, is by being located in the directly affected societies, they have the potential to engage more directly with victims through outreach, to engage in capacity building. They also face a lot of complexities being embedded in the directly affected societies. But I think the U.S. role and leadership, both in helping to set up these institutions, to support them diplomatically, to support them financially, to provide often chief prosecutors, judges, very important participants, has been a very significant factor in the development of this important body of law and forms of accountability. And the U.S. did this for both normative and pragmatic reasons. Normatively, on a bipartisan basis, there was a strong commitment to the norms of international humanitarian law, the prohibitions against crimes against humanity, against genocide, against grave war crimes, and also very pragmatic reasons that in order to try to stop conflicts and to avoid having to engage in atrocity situations that can spill out of control, that can lead to the need for more risky forms of intervention and engagement, trying to prevent atrocities up front, trying to build coalitions and train forces and partners that will respect the laws of war, are very important to U.S. security over time. So it's been both the normative and the pragmatic that have led to the U.S. support for this body of law. Now, there's also a complicated factor, as we all know. The U.S. historically has been more apprehensive about institutions that might sit in judgment of U.S. conduct without our consent. And that's a big reason why the U.S. From the start had a more complicated relationship with the International Criminal Court. While we were there to help negotiate and supported aspects of the court, the fact that it could potentially have jurisdiction over Americans if they were alleged to have committed crimes on the territory of a state party, even if the U.S. was not a state party, was a reason why the U.S. was very cautious and apprehensive and has had a sort of defensive posture toward the ICC from the very beginning. However, the second Bush administration realized that the court, once it was up and running, could potentially pursue cases that were in the U.S. interest and could pursue cases where other tribunals would not be available. And therefore, the Bush administration was willing to support the Security Council's referral of the Darfur situation to the International Criminal Court. The Obama administration, in which I served, saw much of the work of the ICC as being very important to strengthen accountability in situations like Uganda, the Democratic Republic of the Congo, just to mention a few. And the ICC also is built on the principle of complementarity. It gives primacy to national accountability, and the court only can step in if national authorities are unable or unwilling genuinely themselves to investigate or prosecute. And so the primacy of national accountability is something that the U.S. has long supported. And during the Obama administration, took a very constructive relationship with the ICC, helping to ensure that it had certain suspects in its custody, Bosco Ntaganda, Dominic Ongwen, among others, supporting domestic and hybrid action that was complementary to the court. And so I think it found a way to navigate traditional U.S. defensive concerns with the affirmative agenda to support justice and accountability.
Thank you. Tom, I'm going to ask you to address two questions, and the second one is going to kind of pivot back around to everybody. When we talk about the U.S. role in supporting these tribunals, we often see very visible figures like Ambassador at Large for War Crimes Issues, as the title used to be, Stephen Rapp, and both Jane and I served with. But Congress plays such a critical role as well, and a big part of our work in the State Department was, in fact, engaging with Congress because we knew how important your role was. But I don't think it's as widely known, and I wonder if you could say a little bit and maybe talk about the support that you were involved in developing for the Special Court for Sierra Leone, because it's a good example of congressional role.
Sure.
I'll let you do that one first.
Thank you, Diane. We were on the Foreign Affairs Committee, and there was intense concern about what was going on in Sierra Leone and Liberia. And so we held a series of hearings. I've got a photo here. It's a little Sierra Leonean girl who was about 4 years old, who had her arms amputated by some of the rough fighters. And we brought her up. We did it with some trepidation, just given her age and so forth, but it was absolutely essential to build that kind of support and awareness of what was going on in Sierra Leone. And so we held hearings, we passed resolutions, we pressed the administration, which at the time was a little ambivalent about pressing on Sierra Leone, creating the court, and certainly the turnover of Charles Taylor after David had indicted him. He fled eventually Liberia, went to Nigeria, and was harbored in Nigeria for 2 years. And we felt it was absolutely critically important that he be turned over to the special court. And so we had congressional letters. We played hardball. There were threats to the State Department on various appropriations. And we had a nice, very effective bipartisan coalition, House, Senate, Democrats, Republicans, not to get too jargony, authorizers, appropriators, and put a lot of pressure on the administration to support the court, but also, again, to pressure Nigeria to turn Taylor over. Because I think, frankly, without Taylor being apprehended and tried, the court certainly would have been the success that it was. And so I'll just make two other points. That kind of support absolutely would not have happened without David Crane and his team. He was essential. And there's a passage in his book, and I absolutely commend his book. It's excellent, but I'm going to read it. It'll be very quick. Most of my time now was focused on politics and diplomacy. The vast majority of that time spent getting our message out to local, regional, and diplomats, and this was absolutely critical. I was out of the office talking, lecturing, briefing, listening, hosting lunches and dinners, and attending receptions to ensure that I had a solid professional relationship with all the players in the region that impacted the special court. My main focus was keeping up a running dialogue about Charles Taylor, maintaining the political momentum to have him handed over to us. And David was relentless in building that support on the Hill. My boss played a very important role. And to get to Jane's point about it was principled, but it was also pragmatic or practical. And I'll tell you, it was principled because we supported the court, we supported international justice, and I'm speaking for the members of Congress. What we also realized, and this is what David did a stellar job and others on his team in communicating, if we did not apprehend Charles Taylor, this is the practical aspect, the work of the court would have been null, largely because I deeply believed, and I think people in the region believed, Taylor would have come back. When Taylor left Liberia, he had a quote, "God willing, I will be back." And David, frankly, wrapped that quote around his neck and used that in communicating to people who, for whatever reason, wanted to be practical, didn't want to offend Nigeria, felt it would be destabilizing, taking him out of play. You had regional African heads of state who, frankly, didn't want accountability for war crimes. They didn't like the precedent of a sitting head of state being responsible for how he treated his people and how he treated neighboring Sierra Leoneans. And so we pressed on that, and I'll tell one final story. I worked for the chairman of the committee. He was tremendously committed to this cause. And again, the Bush administration was a little hesitant to really press Nigeria on this. And every year, the White House has a Christmas party for members of Congress. So all senators and House members go up, and it's a tradition. It's a grand party. As a staff director, I had the opportunity and privilege to attend a few. But the members of Congress go through a line with the president, and he shakes their hand, and they take a picture. And so Chairman Royce was going up with, he was subcommittee chairman at the time, going up to shake President Bush's hand. And the president knew what was coming. Most members will go through the line and ask, hey, can I get a job for this donor or this constituent or so forth? And President Bush said, Ed, I get it. Charles Taylor. This had been the third time that my boss personally raised the issue with President Bush, and that turned out to be hugely consequential because we ended up leveraging Nigerian President Obasanjo's visit to the White House to his commitment to turn over Charles Taylor. And so David was a hero. My boss played a huge role. There were other members of Congress. Frank Wolf, an appropriator, played a huge role. There were senators. But I don't, frankly, see that kind of it was an exceptional time in many ways, and it was an exceptional constellation of characters, and there was a huge measure of confidence in the Congress in David's competency. And so at a time when there was concern about international justice and maybe not having control, he was a face and a presence that gave members of Congress a great deal of confidence in the court and the willingness to fund it and to press for Charles Taylor. So,
thank you. This is the moment when I should pivot to a question I'm going to ask in a minute, which is, or 5 minutes, which is, what are sort of the ingredients to the success? But sort of as a foundation for that, I think it'd be helpful to hear from each of you how you measure success. Like Tom, you mentioned the apprehension of Charles Taylor, the fact that he didn't come back and create further trouble. But we don't necessarily have a common understanding in the field, even among us who work in it, what counts as success. So maybe I could just go down the row and have each of you sort of identify what you mean when you say this was a successful experiment or a successful tribunal.
There are several measures and many measures, but the one I want to highlight tonight, because I want to make sure we keep a dialogue going, and of course hear what you have to say too, is that international tribunals should be and are for and about the victims. And I was always telling my team from 23 different nations in Freetown, Sierra Leone, that every day we get up to bring justice for the murder, rape, maiming, and mutilation of over 1.3 million human beings. It's the only reason we're here, is to seek justice. We tend to step over the victims as we step off the airplane and go do our mandate, but we never reach down and pick up the victim and ask them what happened, tell us what we can do for you. And we did that in West Africa. And so with the way I personally took as a success was this, that I was able to do the best we could to seek justice for the victims and their families in Sierra Leone. So to me, it's, did the victims feel that some justice has been done? I think there was.
Great, thank you. Jane.
Yeah, I really agree with David, and I had the good fortune of visiting David in Sierra Leone at actually the beginning of the trial of Sam Norman.
Yeah.
And David really, I think, was a pathbreaker in so many ways, but among them was his focus on the victims and engaging in outreach with the victims and asking the victims, who do you think is most responsible? What would justice look like to you? And I went with him on a number of outreach engagements and was extremely impressed by his focus on these issues. And these were very tough questions because many of the victims felt like the most responsible person is the guy down the street who chopped off my arm. And yet the special court was focused on those most responsible in the larger sense, the orchestrators of the atrocities. And so communicating with the victims and explaining what the court could do and couldn't do, and having an honest conversation about that was a really big part of the work of the court. And so it wasn't just about getting convictions at some court far away, but it was engaging with some of these very tough questions about what justice means and what it looks like, trying to do it in a way that is balanced and doesn't focus on just one group, but on any groups that have committed comparably grave crimes. So I think that's a very important measure of success. Due process, doing it in a way that is fair, consistent with internationally accepted standards of due process, is very important to success. And I think also leaving some kind of legacy on the ground. So when you walk away at the end, you've contributed in some sense to the capacity of the affected country. Those are things I would highlight.
I'd say two things. I would say, one, the precedent that being the president of the country doesn't confer immunity. There is accountability. And two, the fact that Sierra Leone and Liberia are peaceful today, 15 years ago after a horrific civil war. And they're still very fragile countries, but they're peaceable countries.
Would you mind saying a little bit more about how you connect that to the work of the special court?
I would get back to the fact, and I guess you always want to guard against being too reductionist and thinking one person is responsible for all the chaos in Sierra Leone. Clearly, Charles Taylor was not solely responsible, but he was majorly responsible. And for those who don't know his background, I mean, it's really, he has an intriguing background. He escaped from a Massachusetts jail. He trained in Libya, in Gaddafi camps. I mean, he's a wily guy. And when he said he'd be back, and when he was in Nigeria, and he wasn't imprisoned, he was in a kind of a cushy exile, we knew he would get back. He had the means to come back. He was on his cell phone communicating. And so, again, I don't want to simplify things to the point where he's off the board, there's going to be peace, but I'm pretty confident that we can say if he was on the board, there absolutely would not be peace. And he wasn't going to sit around in Nigeria for the rest of his life. He would find a way. His wife is vice president of Liberia currently. And so there are deep ties to and strong indications he would have returned. So I feel that I know what Liberia and Sierra Leone would look like today, I think, if Taylor weren't brought to justice.
Yeah, thank you. I'm going to just ask two more rounds of questions and then open it up for questions and comments from the audience. So I want to turn to some of the challenges. Already 7 years ago, the Journal of International Criminal Justice devoted a symposium issue to, quote, setbacks in international criminal justice. We've been talking about the challenges at least that long, and certainly with, in some ways greater intensity now than a few years ago. So, Jane, let me start with you. I'd love to hear your thoughts on it. So it's often said that there's a crisis with the International Criminal Court. International justice generally is facing this new broad challenge. Do you think there's a crisis? Do you think that we are seeing new challenges? Mm-hmm. What's your read of the situation?
Well, I think that do you mean for the International Criminal Court specifically or more broadly?
First the ICC specifically, and then more broadly.
Okay. Well, I think the ICC is in a tough moment. I think anyone who sort of sees things clearly would have to acknowledge that. But a lot of the challenges it's facing, I think, are also a function of long-standing challenges that are to some extent baked into the very statute and effort of the ICC. It faces expectations challenges. People have a lot of expectations about what it can and can't do, and yet its jurisdiction is constrained in many ways. Its membership is constrained. And in many of the worst conflict situations right now, with many of the worst atrocities, it doesn't have jurisdiction, because it has no jurisdiction over the territory of Syria, for example. It has no jurisdiction over the territory of Myanmar. And so there always are going to be gaps between what the court is looked to do and what it's actually practically able to do. There also are institutional capacity challenges. Its role, it steps in only when states are unable or unwilling themselves genuinely to investigate or prosecute. And yet those are the very situations that are the hardest, where you're least likely to get cooperation from the state to gather evidence or to help with gaining custody over suspects. And so there are many aspects about its institutional capacity. Also, unlike the Special Court for Sierra Leone, which was in one country focused on one situation that could have all the focus and the expertise that you develop over time, the ICC sort of has a larger global mission, which means that it can have only a few people focused on any given situation at any given time. It doesn't have the ability to gather the expertise and have the sort of sustained focus that one of the locally based hybrids would have. It also has concerns about legitimacy, in part because its membership is only partial, and many powerful states are not members, and so it faces a lot of enormous challenges, and yet even so, it's had some really substantial impacts. I think the very fact that it exists, that it has, that its statute has articulated the contours of international humanitarian law and the elements of crimes that many states that are parties have incorporated that into their domestic law. I think that's been a very important contribution. I think it's a symbol of hope for many victims. It kind of symbolizes what they aspire to achieve in terms of justice. It's had a number of successful convictions, although obviously not as many as one would hope. It has helped to catalyze domestic accountability in places like Guinea, where the prosecutor has worked with domestic authorities to try to develop the capacity for domestic accountability. Likewise, in the Central African Republic, there's a sort of collaborative relationship between the court and the local authorities. So I think we have to look at its impact not only in terms of its own cases, which is very important, obviously, and they need to prioritize and do a more effective job of gathering evidence and so forth, but also in terms of some of the larger impacts it's having through its catalyzation effect and encouragement of domestic accountability. But even though I see a lot of challenges, I think there are some important sort of trends that are more positive, if I could say something about that. I think there is much more of a presumption of accountability today, in part because of the work that David did and that so many of these hybrid courts have done, the ICC. There's much more of an expectation on the part of victims, affected communities, and the world more generally, that when these atrocious atrocities are committed, that some form of justice ought to be provided. And I think that puts the burden on states that engage in atrocities puts pressure on them to do something. And if they're not willing to do something, it puts pressure on the international community to come up with some mechanisms of accountability. So I think that's a more hopeful sign. I think, secondly, there's strong advocacy for justice from civil society. There are any number of groups around the world, both nationally and internationally, including from directly affected communities, that are advocating, I think, much more effectively for justice. And I think that's an important development. And there also are many innovations, admittedly with acronymic names, IIIM, but the mechanisms, the special mechanism for Syria, for Myanmar, where there are efforts to gather evidence and to build cases and to share that information with courts that may have jurisdiction, whether they be national courts or potentially regional or even international courts. So I think there's a lot of innovation happening and a lot of learning based on prior experience that can provide a lot of guidance and lessons going forward.
David, can I turn to you next? And I will come back and ask you also about lessons learned going forward to sort of continue to make progress in this landscape, which is challenging. But maybe I could put you on the spot a little bit and ask you to talk about some of the challenges presented by the fact that, as we discussed earlier, there have been vicissitudes in U.S. support for these institutions. And I believe you've been in a position of inviting somebody to speak at Chautauqua and her not being able to come because we won't give her a visa, the prosecutor of the ICC. How do those challenges impact where we are today? I mean, how does it affect the current landscape?
Well, it's a good question, an important question. I'll try to simplify it. The United States of America built the house by which most of the countries that deal with international humanitarian law now reside in and work in. And at one moment, we helped them build the house at Nuremberg, Yugoslavia, Rwanda, Sierra Leone, Cambodia, International Criminal Court. We were a leading group of delegates shaping this. And then we took that house that we built and gave the keys back, and we walked out of the house. And that's where we sit today. And what we're really doing now is we're looking in the picture window of the house that we built. I know it's a terrible analogy, but you kind of get my point, is that we've not as effective as a country in this area as we used to be. Our voice is not heard as much as we would like it to be. We can't be in leadership positions or in positions where we can help the International Criminal Court, not just in sitting on the sidelines and cheering, but actually getting in and helping them with their very difficult management situations, etc. So it's very disheartening for me to see this, because again, the United States was always looked to as the country that, regardless of what happens, we could always count on the United States to do and help and do the right thing. And in this, the age of accountability, as I call it, that lasted on or around 20 plus years, we've kind of shifted a little bit into in this, what I call the age of the strong man, this progressivism, this nationalism, inward thinking, this lack of looking more internationally, has really ground a lot of the work that we've done at the international level to a halt. Some of it's just by circumstance. It just so happens just around 2015, 2016, when we see a lot of strongmen seizing power. All the courts that have, during the age of accountability, Rwanda, Yugoslavia, Sierra Leone, we all finished our work. There are no more tribunals. We're done, other than the International Criminal Court. So there's kind of almost an unintentional void that we created in our own success, is that we finished and we have all of this, but then we just have the ICC. And so that, the U.S. is worked with the ICC, it's lived with the ICC, but then under the current administration, the ICC, it's doing its work, has directly tried to impact on its work. For example, every year we invite all of the current and former chief prosecutors and associated colleagues and friends to Chautauqua, the International Humanitarian Law Dialogue, now known as the International Humanitarian Law Roundtable. And every year, most of the chief prosecutors, current and former, come. We have an interesting dialogue on various issues. Well, this year, I always invite my friend Fatou Bensouda, who's the chief prosecutor of the ICC, to come, because she's always come, and she was not able to come because of her visa was revoked by the Trump administration because of her work doing investigating allegations against the United States and other countries in Afghanistan. And so that was a direct threat to her work, and just sent, and you put it simply, because I'm kind of a simple guy, it just sends the wrong damn signal. I mean, it's just almost the culmination of us giving those keys back in the House. And so at this point in time, we're working on making sure that that doesn't go unnoticed. And there's a group of us who are going to probably start some litigation related to the refusal of the United States to allow Fatou Bensouda in to participate in a free, open roundtable on issues that are of interest to the United States as well as the international community. And so there's going to probably be litigation on this, and we'll see where that, as we say in North Carolina, where I live now, we'll see where that dog hunts.
So the last question I wanted to ask is a really small, tiny, simple question. Maybe I'll start with you, Tom, and feel free also if you wanted to add anything to the last round to do so, which is basically, what are your thoughts about what we've learned from the past now 25 plus years of contemporary experience with war crimes tribunals? What can we learn from that experience that might equip us to meet the challenges that we're facing today? And as you noted earlier, we've always faced challenges. I love the way you talked about Charles Taylor, because right now it's sort of easy to think of that as something that was destined to happen, but anybody who was there at the time knows it was not destined to happen, and it was a huge challenge. And it was possible to pull together a lot of resources and skilled people to meet that challenge. So if you have any thoughts based on experience about how we might find a path forward.
Thank you. I am not an international law expert, but I guess I would just underscore this issue of practicality, and I think perhaps trying to build the broad support for courts, it takes more than just an appeal to justice. It takes some, I don't want to say more of a tangible sense, but just to go back to the special court, we knew, yes, we cared about justice, but we also believed strongly that there was a very practical element to this, and that was bringing stability to the country, getting Taylor imprisoned and building that stability. And so I guess I would just throw out in an attempt to broaden support for the very meritorious principles of international law and accountability that we all stand for, maybe the way we explain it to people in Congress and American citizens is to challenge ourselves to look at the real world circumstances of a particular injustice and try to frame it out. Yes, it's justice, but it's also peace and stability to a particular country or a region. So,
Thanks. Jane?
Yeah, no, I think that's a terrific point. And not only in West Africa, but you look at Syria today, for example, the hemorrhaging of refugees, the horrific atrocities, the impact it's had in Europe, and the destabilization in so many countries. So that not only are atrocities inherently bad and raise moral issues and demand a response, but they have security consequences that can be devastating. And responding effectively is both a moral imperative and a security imperative as well. So I think that is a really important point. Secondly, there can be bipartisan support for this kind of work. I mean, there's a lot of support on the Hill with respect to atrocities, dealing with atrocities in Syria and so forth. And so this is something that should be able to cross the aisle and be something that enjoys broad support. Also, that the U.S. can and should be flexible about different ways of achieving accountability. I think we shouldn't let our obsession with the ICC overcome our deeper commitment to the principle of accountability, and we should continue to work for national accountability when it's possible, innovative hybrids like the Special Court for Sierra Leone, and the kind of innovations that David was so instrumental in putting forward. I mean, he worked so hard on outreach, on communicating with the victims. He worked very hard on capacity building within Sierra Leone. He was extremely effective at diplomacy, both in the region and here in Washington. We need that kind of practical entrepreneurial flexibility, as well as a deep commitment to accountability. And so I think going forward, I look at the importance of domestic capacity building, the importance of innovation, in the form of different kinds of hybrid arrangements. I think the importance of prevention. I see we've got Jim Finkel here, who's done so much on the atrocity prevention efforts of the U.S. government over the years, and many of you are involved in this. I think we need to really continue to focus effectively on prevention. And also the importance of a combination of justice mechanisms, not only courts, but also truth commissions, reparative justice efforts, because it's in combination that you can have a bigger impact on justice and accountability with these a variety of efforts. In fact, a lot of social science shows that it's when you combine courts and truth commissions that you have a better impact over time on stabilizing democracy and protecting human rights.
Thank you.
The bright red thread of international criminal law is politics, with a small p, not the type that trying to influence an outcome, but just being able to create an understanding and a willingness to seek justice for victims. And that can take many forms. That's still very, very critical. I think the ICC needs to work on that a little bit, but I certainly concur with my colleagues, Tom and Jane, related to being more open about how we approach. It doesn't always have to be an international tribunal. There's no appetite, practically, there's no appetite for it right now, and I don't see that in at least the short-term or medium-term future related to a lot of these things. But again, you have to be able to continue to move forward, and to also to remind people that these events take place on the backs of human beings. And I'll just give you a short vignette on, I'm the co-author of the Caesar report, and which showed that the Assad administration was committing atrocities in the detention facilities, and we were able to interview and write a report on Caesar, who we named Caesar. He was a sergeant in the Syrian army, a forensic photographer, and he was smuggling pictures of 54,000 high-definition photographs of tortured detainees, and we were able to interview him. The country of Qatar was concerned about the authenticity of this. It just seemed almost like too good to be true as far as direct evidence of atrocity, which is very, very rare in this business. So we confirmed it and wrote the report, and the rest is history. But the impact of those photographs, starting when I briefed the Security Council on that, all the way out now to where they were on display at the United Nations and the Holocaust Museum, etc., watching the people look at these and really visualize horror. The same thing happened at Nuremberg, too. It was very abstract. And obviously people who stumbled upon the concentration camps, obviously hit them in the face, but the world did not know. And I think this is the beauty of past and future courts, is they create a record of exactly what, not exactly, but what happened, and shows the world what happened to the victims. And we saw those photographs of them bulldozing bodies at Auschwitz and Dachau, what have you. And the world at Nuremberg, when they showed those photographs, the trial changed almost fundamentally at that moment. When Robert Jackson showed the army film of that, and the world began to realize that this is not just an abstract idea, but a very personal and an immediate one. I'll close with the vignette. I was at McKinney. I'm not sure you were there, but it was about the time you were there, in March of 2004, at the former headquarters of the infamous Revolutionary United Front, who did all the chopping. And I was in a town hall meeting. It was a group. Many of them had been victims of the RUF, ruined in some way. And I was about halfway into about a 3-hour session, and I would stand among them, not above them or in front of them. I would just go and stand among them, much to the concern of my close protection officers, but they learned to deal with it. But a young boy stood up. He was about 12 years old, and he said, I killed people. I'm sorry. I didn't mean it. He fell into my arms crying. And he was a child soldier. He was a murderer and a rapist. I found out later that he was 12 years old. And so as he's weeping in my chest, a young woman stands up about from A to U, and she's holding a baby, and she's missing half her face, missing an eye, and she looks me in her good eye, and in Creole, says in a very cracked voice, she has damaged vocal cords and lips, seek justice for us. So regardless of how the political winds ebb and flow now and in the future, we really do have to understand that this is about the victims. There are human consequences. There are obviously political consequences and diplomatic consequences. But again, at the end of the day, we have to ask ourselves, do we want to live in a world that just allows this to happen unaccounted for? And I think if you can think of that question, then it might be able to allow us to move forward in continuing to seek justice for that little child soldier and that young mother, and the multi-millions of those types of victims.
Thank you, David. Thank all of you. I do want to open the floor up to questions. Is there a Okay, great. Any comments, questions?
Thanks, everyone. That was really terrific. David, you mentioned that you don't think the international community has an appetite for new tribunals, but I'm wondering what you think about proposals that are being floated to essentially go back to a Nuremberg model, where you have a group of willing and like-minded states that would come together to form an international tribunal that might be focused on Syria, let's say, or one of the places that fall outside of the jurisdiction of the ICC. Is that legally possible, and is it, as a practical matter, possible?
That's a great question. And again, the way I'm actually hopeful, despite what you may have felt, I'm actually hopeful because we've already crossed the Rubicon. Back in 1993, 94, we decided we're going to do something in some form or another. There's no cookie cutter approach to atrocity. So that's important for us to realize as well. We shape and mold these situations. Remember, these courts, tribunals, mechanisms, whatever you want to call them, are creatures of political compromise and political events. And so that's why I said the bright red thread of all this is politics. You have to work the political situation and shape and mold whatever is desired into a way that we at least start some kind of accountability. So I think that there is, yes, right now there appears to be no appetite, but that doesn't mean nothing's being done. We've kind of gone through like waves. First wave, second wave, and third wave. It's kind of a thing I've been kind of writing about and talking about. First wave was Nuremberg. Second wave was the age of accountability between 1993 and 2015-ish or so. And now we're kind of in the third wave where the winds have shifted slightly away from international accountability, even though there is a desire to do that. And the practical aspect of this, more of this nationalistic approach to world affairs, it has affected us. And so what has happened? How has that affected our work and accountability? Well, I call it the third wave, and we've just sought other ways to continue working forward. The mechanism process is one of them. We see more courts, domestic courts, particularly in Europe, now prosecuting individuals who may have harmed a citizen of their country, but in Syria or wherever it may be. So we see a domestic approach. And then we just see the civil societies around the world, small ones, big ones, what have you, are just taking up the mantle and continuing to work in ways that we can hold individuals accountable someday. Like the Syrian Accountability Project, the Yemeni Accountability Project, the brand new now Venezuelan Accountability Project, and others. These are just examples of where they're actually building dossiers on individuals, just like we did in the professional world of tribunals. They're doing that now in their own way, so that someday when a political decision is made to shape something, whatever that may look like, domestically, regionally, internationally, that can happen. And which leads me, Beth, to your question. I do think there's a legal basis by which countries can come together and agree to create something, whatever that may be, a court, a tribunal, or some kind of commission, or whatever they want to call it, and deal with it. I mean, I've always said the best justice is justice by local justice. In other words, as people talking about Syria, I would love to see Arabs create Arab institutions that prosecute Arabs for harms against Arabs, because that's what we should do. It shouldn't be just the international community stepping in and misunderstanding culturally what all this means. So it's important that we do and encourage that, and I think we should continue to do that. So I do think, in fact, I tried to, it's not going to happen just for political reasons, but I was really hoping, and I was working very closely a couple of years ago, and it just hasn't come to fruition, with the Gulf states to create a regional tribunal to deal with Syria and others, Yemen and what have you. I was kind of encouraging them to be a bit more broad. But they'd all sit down, and we'd all sit around and drink tea and talk and agree and all this stuff. And I go, well, I agree to do this, but this guy I don't like. And all of a sudden it unravels, and the Sunni, Shia, or oil, and then all of a sudden thrown in with Saudi Arabia deciding to go after Qatar for whatever reason. It just blew up in my face as far as bringing that go. But we really were close in getting them to at least to agree that this might be but I think there is a moment. I think there is a regional capability, and I think that would be great, because right now, create another ad hoc or hybrid or what have you at the international level, I just don't think the political will is there, despite the great need for it.
Yes, Bruce.
One issue that's been important for the tribunals has been the inability to follow the money and to freeze it, to be able to use it for victims. So for instance, Charles Taylor, who is reputed to have amassed a big fortune, he received millions of dollars for legal assistance that had to be paid. So do you think there's been any progress in dealing with providing the mechanisms for the different tribunals so that they can do a better job of having the capability of finding the money, freezing it, and using it for accountability purposes?
Well, we went after Charles Taylor's money. It's about $455 million, which he squirreled away in he's a gangster, so he knows his business. As soon as he saw the snowball coming down, this rather large one, he diversified. And so we were able to grab about from the Swiss about 10 million of that. But it's complicated, it's difficult. That is the ultimate political kind of Gordian knot, because if we wanted to go to, for example, the Treasury Department through the State Department in your offices to get some kind of sense of what this is, because they are more capable of following the money. Because at the time, the tribunals we just didn't have the finance capability. I had two individuals who were good at this and did it professionally before, and that's where we're able to at least get $10 million of his money. But we're at the time, and I still think we're not that good. We don't have financial investigators, so we have to rely on countries who are good at it, and the United States is good at that. But when you approach that, and with that, everything that you carry with the baggage of your court comes through the door with you. And so if they're mad at you, then that's a problem. If they're happy with you, that might be okay. But it's not consistent, and it's patchwork. And so I think it's a weak point. I believe very much in follow the money. It's very helpful. It's not definitive, but it's certainly important. And also allows us to, now we did have the authority to, under our sentencing, to impose a fine on somebody or, seize their assets, which all of them pleaded that they were indigent, except for Charles Taylor. So we couldn't go after that. So we weren't really prepared to do that. And therefore, there was no money. Because I was my town hall meetings. It took a long time for the victims who I met with in the thousands for them to realize they thought the court was there to get money for them. In other words, find these guys, squeeze them, get their money, and hand it back over to the victims. And it was a very engaging and long-term, probably 2 years before they actually began to realize that I wasn't going to give them cash, I was going to give them justice. But they're interested in cash as well. So it's a long-winded answer that, we are not good at this. And I think we need to be better. And of course, the ICC has a unique capability within their statute where victims are represented, and there's a whole fund that is building up. I don't know exactly where that is right now. Jane, you might be able to help me out on that. As far as, is there any money in the fund? How much is in the fund? Are they distributing? Has any funds ever been distributed?
There's the trust fund for victims where states can voluntarily contribute, but part of the problem is that there are many victims, and you technically only are eligible for reparations if there's a conviction in a case in the situation that directly affects you. So they have a broader also assistance mission as they need to, because there are many victims who will never be within the ambit of a particular case and technically be eligible for reparations, but they need assistance. And so I think they're deliberately trying to broaden the scope of what they can do through that trust fund.
It's a very contentious issue because the victims want more than justice. They'd like to have some kind of money in their hands, and it just isn't happening at this point. Everybody's aware of it, but that doesn't help the victim.
I wonder if you could speak more about the role of civil society in gathering legally admissible evidence, especially in a context like Syria, where they're the only ones who really have access to the ground. You spoke about the value of having a tribunal in the location, but in the context of Syria, where that's not possible now, what can civil society organizations do today to gather admissible evidence for future prosecutions?
That's a great question, and actually, it's a question that we all need to consider. Those of us that are in the business, want to be in the business, because it was a unanticipated surprise and challenge, and that is not just what you're really talking about is data in the petabytes, which I think is 1 million terabytes coming at you, and none of it is admissible in court. None of it. And it's a tsunami of information coming at you. I remember when we were investigating and creating our cases in West Africa, we were just doing it, that was just 15 years ago. We were doing it like you would think. Investigators going out with a pencil and a paper and go, what happened here? Being a little bit simplistic, but it was just really pen and paper and physically going out and interviewing and finding the evidence. Now, we have this situation where all this data coming out of Syria, and when we created the Syrian Accountability Project, which was literally 2 weeks after Darna, I was invited to address and work with a nascent group of Syrians who would call themselves the Syrian National Congress, I think at the time, in March of 2011. And they said, what are our options? I said, what do you want to do with them? They said, we want to kill him. I said, well, if you want to create a new country, that's probably not a good way to start your new republic, is killing the past leader. Obviously, he's a bad guy, but let's back that off. But like anything, you have to let them vent. So for a half a day, they shouted and hollered. And then we worked our way into options, local, regional, and international approaches to justice. And as I was flying back, I said, I don't know if they're going to be able to do this. So we started to build a case against these individuals, and have been doing it ever since. But I also reached out to then what was becoming a cottage industry of NGOs to the tune of, I don't know how many, none of which were really doing anything significant, but causing a lot of problems. I'm being quite frank about that. There were some very good ones, but that was like 5. The rest of them were creating their own mandates to raise money to create more mandates. And there was much in running, but there's a lot of dust in the air, and there continues to be a lot of dust in the air. So we have all of this stuff on social media that our diplomats in the UN say, well, we've got all this information. We've got this guy cold. And I told them, no, you don't. He said, well, look at all these videos. Look at all this stuff. I said, well, if you told me now you're the prosecutor, I can't put that video into to evidence. Who took that video? When was it taken? Et cetera. Authenticity, relevance, and all the rules of evidence. I said, those haven't changed. But yet we've got all this data. So you create data to turn it into potential criminal information, which may someday become evidence, was the genesis of the IIIM, the International Independent and Impartial Mechanism. Is that my going in approach was, we got to get professionals taking this data and turning in, from Syria and molding it into a case against those who are committing atrocity. And it's a huge problem. I mean, we're getting better at it from a legal point of view, but the law always follows technology. So the judges don't understand a damn thing you're telling them, and they don't know why that is important. And as soon as you start talking about metadata, their eyes just go. So it's a practical challenge as a prosecutor as well, is once you even get this stuff, there's going to be objections by the other side, and you're going to have to prove its authenticity, what have you. You can do that now, and we're getting better at it, but it's a huge huge problem. And so we're trying to tackle, and it's very disjointed right now. Everybody's doing great. So there's some really good efforts going on, but that effort isn't talking to that effort. And I don't think countries have paid a closer attention. Having been an old intelligence hand once upon a time, I know they know things because I used to know those things. And I know they have methodologies that can be helpful, but they can't be helpful to you because a lot of it is classified and it's tradecraft and all of that stuff. But now with the advent of apps and all of the technology that's around, we now are start working our way. I know that the IBA is doing some good work, but there's no centralized way to do this. And so what I'm starting to advocate is we actually have we come together and build a methodology. In other words, we bring all of those who are doing this and come up with because the judge is going to say, all right, I want to admit this technological thing. What is the standard of practice that assures me that this is correct? We don't have that. So like things like we do in forensic sciences of all sorts, we actually have a standard of practice on this. And so that's what we need to do, is to bring all of the good things that are being done into an industry-wide standard of practice. So when we do bring that evidence in from Syria or wherever it may be, gleaned out from the social media and all of this data floating out there, we can say that this was put together according to our industry standards. You bring an expert in who describes the industry standard, and he says, yes, this is a correct way that we've done it. We don't have that capability. Therefore, a lot of this stuff doesn't come into evidence. So if a judge is assured that it's relevant and it's authentic, et cetera, probative, and all those things that we learned in evidence in law school, the point is that the judge is still going to ask, what is the industry standard? And if it was within the industry standard that we all agreed to, then it's going to come into evidence. But we don't have that. And so I think what we need to do is we need to develop that capability of bringing all of the smart people together and creating an academy that develops a standard of social media information processing in atrocity situations or something like that. And so we're doing that, and a lot of that is through what we've created, the Global Accountability Initiative, and that's something that's going to be looked at where we just build it. It seems nonsense. I mean, it's like, well, why didn't we do that? We should.
I just have to note that in this period of supposed crisis for international justice, this conversation between the two of you just now is so typical of what's actually going on in so many places.
Yeah.
There's so many people doing so many things, doing really hard investigative work, like really difficult investigative work, forming coalitions, strategizing, brainstorming, coming up with new solutions that are fit to purpose for a different time and different set of challenges than we face. And we're always going to continue to do that. But as James Stromseth has said many times and said earlier this evening, there is this demand for justice in so many places. And I think that's what kind of keeps propelling these efforts forward. And often the solutions come from the ground. I'm sorry that we didn't have time and won't have time to talk more about Hissène Habré, which Jay mentioned earlier, but that's a wonderful example of how victims' demands for justice push diplomats to find solutions. I can't remember where it stood when you were in the State Department, Jane, but when I was there, Ambassador Rapp spent a lot of diplomatic time trying to find solutions to what were then impasses to getting extraordinary, extraordinary court I forget all of my names because they all rearrange the same words. So I was about to say, extraordinary. I'm going to say extraordinary African chambers. I think that's it. There was so much hard work and really difficult, protracted diplomatic effort. But what was really propelling that and keeping that going was victims who insisted on justice for atrocities that happened, 20 years earlier. And that is so typically the case. think we may have time for one more question.
So this is cheating because I'm also serving as host, but this series is under our Atrocity Prevention tag. So I wanted to, Tom, you mentioned, the ways that this was looked at as a way of promoting stability. And we've seen recently things like the Genocide and Atrocity Prevention Act, and just 2 months ago, the Global Fragility Act now, that the US Congress has actually taken a more proactive role in looking, how can we not have to be dealing with justice issues? How can we move upstream? Do you see more of a role for Congress in this? Do you see this as potential ground where the legislative is actually taking a little bit more proactive of a stance and requiring the executive to do, or report, at the very least to report, to the limit of what the legislative can actually require executive action?
No, I think that's a great point. There's a great deal of enthusiasm about the Global Fragility Act, which was part of the budget deal that went through in December. It authorizes $200 million per year for various activities to diffuse conflict before it erupts. But like anything, Congress passes a bill, that's just the beginning of the story. The administration has to implement it, and that requires pretty dogmatic oversight by Congress. Sometimes there is a tendency amongst politicians, you pass the bill and you celebrate and go on to the next thing. So I think it's very important that we stick to that. It's an excellent piece of legislative work, now statute, and we just have to make sure that there is that kind of focus on it, and that we can try to diffuse conflict before it erupts, and we have these horrible atrocities to try to deal with. So.
And I should say, as someone who worked in the Obama administration on the Atrocity Prevention Board, as did Diane, there's a lot of expertise now throughout the U.S. government, at the State Department, at Treasury, at the Department of Defense, at AID, on atrocity prevention and early warning signs and what effective action can be taken. There's a lot of expertise that I think should continue to be deployed effectively toward prevention.
Thank you for that wonderful question. Thank you for a terrific panel. Thank you all for being here.
Thank you.